Well, another week and another batch of very significant developments for employers and businesses and organizations here in New York or with New York operations. We intend to cover those today. Glad to have you with us. Please do complete the survey at the end of this program. We welcome your feedback. We read it every week. We take it to heart. And again, we want to make sure that our program continues to be helpful and topical for you. I have a couple guests today who are joining us to talk about certain topics, but before we do that, I wanted to touch on and go through an issue that I'm sure is on your desk and pretty high up on your to-do list, that being New York's recent pronouncement of a masking mandate really across the board here in New York. I want to talk a little bit about what that mandate entails, who is covered, who is not covered, and then address some practical issues and some of the FAQs that we're getting already. Just a preliminary note before I dig in on this. We started this program many months ago at the outset of the COVID pandemic as a service to our community. And very frankly, just to try to share some information with you all, recognizing that the pace of change and developments was unprecedented, certainly was from my perspective. The information that we share to you and with you, however, is not legal advice. And I want to make that point very clear to you. We're sharing some thoughts, we're sharing some reiterations of information that we've seen and things that we've come to form as a belief, but that's not intended and nor should it replace you seeking appropriate legal counsel on these issues. And I think this masking mandate is no exception to that. So with that caveat, why don't we dig in here and just kind of go through the particulars. So really there's three things, and I'll put these links after I'm finished speaking. I'm going to put these links into the chat function so that you have them. But there were three pieces of guidance and authority that are relevant here. This started with promulgation of a new regulation that replaced a prior regulation dealing with masking here in New York. You see where that is codified there. And that really is the launching pad from a legal standpoint, right? The regulation sets forth the initial terms. And then from that, we had a determination from the New York State Department of Health Commissioner. And I would say that's really the key document here. If you're looking to have a document on your desk, that's probably the best one. The FAQs that the Department of Health published at the same time that the determination was published is also a useful document. It's something I'm keeping handy on my desk right now as we face a number of questions. And on that issue of questions, let me say, I'm expecting I'm not going to have the opportunity to simultaneously look at all these questions and answer them as I present this information to you here today. But keep those questions coming. I would say let's not sacrifice taking a look at the information that we're presenting here, but please keep those questions coming. I know that Adam, my co-host, and I will be reviewing that information afterwards. I suspect that we're going to put on a standalone program for our clients, at least before the end of the week, drilling down into some of these issues. So we welcome your questions there. Again, today is designed to provide you with an overview of the requirements, hopefully confirm some information that you may have a question on, and then to deal with some of the FAQs that we're seeing so far. But it's not intended to be a soup to nuts, comprehensive review of these requirements and every conceivable issue that may arise. But again, keep the questions coming. All right, so with what I'm going to share with you, I'm working from the commissioner's determination as well as the FAQs to fill in some gaps that are here. But what we saw in the commissioner's determination is a breakdown of certain types of operations. And this breakdown was consistent with what we saw beforehand when it came to masking requirements. So we saw a separate breakout for operations in healthcare settings. And by that, the commissioner's determination is very clear that those are facilities or entities that are covered by Articles 28, 36, or 40 of the New York public health law. And in my experience working in that sector, you know who you are when it comes to that coverage. If there's a question on that point, certainly seek legal counsel. Those requirements for the healthcare setting with respect to personnel say, hey, masking is required for all, regardless of vaccine status, period, full stop. For visitors, there's a slightly different requirement. It says if people are over the age of 2 and they can medically tolerate the mask, they're required to mask regardless of their vaccine status. With respect to adult care facilities, and again here, in my experience, you know who you are, but seek guidance if you're unsure. The personnel requirement is more nuanced than in the healthcare setting. It's more nuanced insofar as the masking is required if that employee is providing direct medical care, regardless of their vax status, again here, have to be masked. And with respect to other staff who are not providing direct medical care, they at least have to have some type of cloth covering over their mouth and their nose. And with respect to visitors to an adult care facility, the masking is required over the age of 2 if they can medically tolerate it. Interestingly, there's no reference here to vax status when it comes to these visitors. I'm not sure what to make of that. If the intent was to create some type of exception, if someone is vaccinated, again, I think that may be reading a bit too much between the lines there, but it was something that I noted in the guidance. So beyond these two areas, we also saw the commissioner's determination addressed the school setting. And I know this is interesting to me as someone who practices in this area, but also who has a son in high school right now. And many of you are in the same situation, I'm sure. The language that was used in the commissioner's order with respect to these schools was that universal masking was required. We saw that language is different. I'm not sure it's a distinction with a difference when it comes to those other areas that we talked about, but they said universal masking for teachers, staff, students, and visitors over the age of 2. Again, who can medically tolerate a mask regardless of their vax status. This also extended to any gatherings that are in school or on school grounds which address or implementing educational matters where students are present, expected to be present, or can reasonably be expected to be present. The guidance was also very clear that there are no mask breaks permitted under this policy. There's no social distancing that can exempt a student in a classroom from the masking requirement. So again, we see a very significant onerous set of requirements here for schools to follow. And again, no discussion in this guidance of what an employer in these areas or an operator in these areas should do if you have someone who cannot medically tolerate a mask. What do we do in that situation? And again, I don't think there's a one-size-fits-all answer to that question. And if someone tells you there is, I'd be skeptical. Rather, what I think you need to do in those situations is take a step back, work with your legal counsel, and identify the issues and a compliance approach that you're ultimately comfortable with. The commissioner's determination also covered operations at correctional and detention facilities, homeless shelters, and public transportation, both mechanisms for transportation as well as hubs for those transportations. And again, we see that similar to the breakdowns previously in place with respect to masking. If you have operations in those particular areas, just out of concerns for our limited time here, I wasn't going to go into them, but you can see the guidance that is specifically set forth in the commissioner's order. We've also published an article on our blog, the New York Labor and Employment Law Report, going through those details as well. All right, so now we get to it. And I should add, previously, that's really what we were dealing with in terms of the scope of entities where there was a concern or specific directives on masks, which was supplemented, of course, by the HERO Act and the HERO Act requirements that at least employers in New York were required to adhere to when it came to masking and conformity with CDC recommendations that were adopted by the state. But here we have a new, I think, substantive area, and this is where everybody's attention and focus is on right now, because it's essentially a catch-all, as we read it right now, and a very broad coverage requirement. So we had those other entities that I just mentioned to you, and then there was this additional area, again, that was covering all indoor public places not otherwise covered by the determination. So from our perspective, this encompasses a wide range of operations, including employers, offices, businesses, and other entities that didn't fall in those other categories that I just mentioned to you before. And this, for those additional entities who are subject to the catch-all requirement, again, it covers all persons, right? Not just employees, but all persons who enter those facilities who are over the age of 2 and can medically tolerate a face covering or mask. And again, regardless of their vaccination status. Notably, this particular area, again, not necessarily those other areas, but this particular area says that the requirement will not apply to any indoor public area where the entity requires proof of vaccination as a condition of entry. So I think the proper way to analyze this is to say there's a masking requirement that's in place. It's very broad. It covers what you see here with respect to these operations. But if an entity elects to implement a uniform vaccination requirement for all persons who are gaining entry and obtains proof of that, then that obviates the need for the masking requirement under the order. Many questions we've gotten, one I've included in the FAQs, but when you see the term indoor public place used, I think oftentimes we think about government facilities, maybe other facilities that are generally open to the public. And here the determination, despite using that term, was very clear that it intends this far more broadly. And again, it's any indoor space that is not a private residence. Also, there's a specific date delineated on this particular element that we're talking here. It's until January 15th. I note that the other areas and sectors that I mentioned to you in the previous slides do not contain a specific date. Rather, it says that the requirements will remain in place in those areas until the order is either modified or withdrawn. All right, so just a couple additional points from the commissioner's determination. First, there is a discussion about, hey, nothing in this should be interpreted as being inconsistent with the ADA and workplace safety guidelines. So keep in mind those obligations that you may have to reasonably accommodate an individual's disability still apply. And in the determination, there's repeated references to the CDC's masking recommendations. Time and again, it's in there. And it's notable because those recommendations have changed over time. So this is something that I think you are, as employers, business operators, owners, leaders of your organization, you're going to need to pay closer attention to the CDC masking requirements and recommendations. And it's especially important, not only because of that linkage that I mentioned to you, but the state has also said that we won't necessarily update the commissioner's determination based on those changes. So keep an eye on that. I think additionally, to the extent that those CDC recommendations may provide some exemptions or other circumstances that are referenced there, that may need to be included as part of your decision-making process and how you handle and assess these issues with respect to the masking requirement. Okay, so we've included here a few questions and a couple slides that I want to talk about. Again, I know you're going to have many more questions. Please keep them coming. We'll look at them. But here are some of the things that we've seen just in the short period of time since this requirement was announced on Friday. One of the questions that I got frequently as an initial matter, although they seem to drop off, was one that I referenced before. Hey, my business or my operation isn't generally open to the public. Rather, we have security. We have doors that are locked. People can't just come in to our facility. Does this masking requirement apply to us? In here, I would say it does. And the guidance is very clear, as I pointed out earlier, that the definition of an indoor public place really is essentially anything other than a private residence, as far as the state's guidance is concerned. Another issue that I believe many entities are contemplating right now is whether it makes sense to implement a mandatory vaccination requirement. To this point, entities that have not otherwise been required to under the law, in my experience, have been somewhat hesitant to do this. I just haven't seen in the course of my practice a large number of employers who are not obligated otherwise under the law to implement these vaccine mandates. But I think this question is arising now with greater frequency. And quite frankly, the masking requirement has put this question into sharper focus. I can't answer this question for you. It's going to entail, I think, a number of factors and decision points for you and your organization to consider. Not the least of which is, the impact on your operations. What's the impact on your personnel and your staffing? How will customers or other members of the public who you may rely on for your business react to imposing a vaccine mandate to enter your facility? What are you going to do with employees or members of the public or customers who may be unwilling to be vaccinated because of personal beliefs or a matter of principle? As a corollary, what will we do in a situation where we have, in theory, imposed this vaccine requirement, but we have individuals with bona fide disabilities or sincerely held religious beliefs that prevent them from getting vaccinated? We're all aware, and you've heard us discuss repeatedly about an employer's obligations to reasonably accommodate those situations. What that reasonable accommodation may entail is going to be different and will depend on your particular business or organization and its operations. Again, no one-size-fits-all approach there. And another question that I think is tied to this will be, well, okay, if we impose this vaccine requirement and we have this concurrent obligation to reasonably accommodate an individual's sincerely held religious belief or disability, well, how do we do that and still comply with this masking requirement? Is there a path that we can find? Again, here, no one-size-fits-all answer, but these are the types of issues that we here at Bond have been working with our clients with extensively. And I'm confident in saying that ultimately it's going to be a question of risk, tolerance, and trying to fill in the gaps that we see here in terms of compliance. But this is not a new exercise for all of us. We've been here before, and I'm confident that working together, we can find a path forward that makes good sense for your business or organization. Again, I think I've covered the third one here. The guidance really doesn't speak to what we do if somebody cannot medically tolerate a mask, but I think you're going to need to go through that reasonable accommodation analysis, have that interactive process with the individual and make an assessment accordingly. What about eating and drinking? Again, the guidance that's out there, both the FAQs as well as the commissioner's order, does talk about this. And my take on it is it puts a bit of a finer point on this. I thought this was, in my experience, always a bit loose, particularly if you're out eating at a restaurant or picking up food somewhere. Even when we were at the more strict times, what I'm seeing here is it seems to be a somewhat tightening of this. And I think of when I've had to fly in recent times, and I've been advised that I really need to keep my mask up when I'm chewing. It's really that small moment when I'm taking a bite of something or taking a drink and then replacing my mask over. The guidance doesn't go quite so far as to say that, but they use the term actively eating. So again, that raises a question in my mind as to exactly what does that entail, and how strict is the masking requirement in this circumstance. Likewise, well, what if eating and drinking is part of my business? What if I have a bar where people sit at and communicate with each other and drink? Again, the guidance from the state talks about actively drinking or eating. And if that's not taking place, then the mask needs to be in place. Again, assuming you haven't imposed a vaccine requirement. With respect to the HERO Act, how quickly we forget, right? We still have this HERO Act in place. I could see this, your HERO Act plan in the HERO Act itself did tie requirements to pronouncements from state officials, including the State Department of Health. And I think this order can be fairly construed as being a requirement that needs to be adhered to as part of our HERO Act plan. Now, depending on what approach you take, there could be certain amendments that need to be made to your HERO Act plan and certain communications that you're going to want to make to your employees. And also, if you happen to be a workplace that has established one of these workplace safety committees pursuant to an employee or employees raising her hand or their hands requesting to make one of these committees, this could be an issue under their purview and requiring their review of these developments too. So another thing to keep in mind. So moving beyond these issues, some other questions that we've got are again, for the vaccine exception is what I'm going to call it from the overall masking requirement. Again, individuals have to be fully vaccinated. Does that mean that they have to get a booster shot? Not yet, and not in the guidance. It just talks about 14 days having passed since the second dose in the case of the Pfizer or the Moderna, or 14 days after the initial J&J dose. There's some other permissible types of vaccines consistent with WHO approval that I won't go into detail here, but again, with respect to the three that we're all familiar with, it's the same definition of fully vaccinated that we've been dealing with thus far. We'll see if that changes, but right now that's it. Another common question that I've been receiving, and others have too, is, hey, can we incorporate some kind of hybrid arrangement where, given our operations, we're going to require that certain staff are vaccinated, where we are comfortable and confident that it's sufficient for other areas of our operation or staff to simply be masked. And again, I think when I take a step back and look at that, that could make very good sense in any number of circumstances. Unfortunately, the guidance seems to take a negative view of this and characterizes the situation as really an all or nothing. In other words, you either mask, or if you don't mask, you have to mandate uniform vaccinations across the board here. Again, I think you still have to consider the potential accommodation issues that we've discussed already, but that opens up, I think, any number of questions. I would say here, as you look at this and you look at your operations, especially if you have different facilities, I think this is an area where you're going to want to talk to legal counsel, contact your favorite bond attorney. You can contact one of us on this program today, and we can work with you to provide guidance on that. I've seen a number of county leaders come forward and advise that they do not intend to enforce these masking requirements. The regulation that started all this and the guidance makes very clear that it is left to local authorities to enforce these requirements. I heard a number of reports talking about insufficient resources available to enforce this, and that's led to questions once these pronouncements have come out as well. Hey, look, if my county is not enforcing this, do I still need to follow it? Again, it's a mandate. The state is requiring this to happen and has left enforcement to the localities. Ultimately, I suppose it's a question of your risk tolerance when it comes to the enforcement, but I think there's other factors to consider too, not the least of which, of course, is the welfare of your workforce, your customer base, and members of the public who may interact with your business or organization. Those are all important factors to consider. I would add this too. We've seen where there was prior intentions for enforcement to be pushed down to a local level. that there's still interest on the part of state regulators. And from my perspective, it's entirely conceivable that you could have an official from the state AG's office or from the State Department of Labor contacting your business and questioning your compliance with the masking requirement based on a complaint from an employee. I'm not sure, and I'm a little skeptical that they're going to refer every individual back down to the local level. We'll have to wait and see. And the consequences for noncompliance are fairly significant. Of course, there's the issues of the health and welfare of your workforce, members of the public and customers. That is certainly paramount. In addition to that, there are financial penalties. The penalties are, I believe, $1,000 per day of noncompliance if demonstrated. So again, there is some teeth to this. Finally, are there some times when employees are free not to wear masks at work? The guidance talks about, if they're actively eating or drinking during their meal period, that's fine. They can have it off while they're not actively eating. And then the other bit talks about when they're in an enclosed area. Lots of questions on what that means. What is an enclosed area? What is not an enclosed area? Is a cubicle that somebody's in that's quite a bit of distance away from somebody else, an enclosed area? I would tell you this: the guidance and the determination from the commissioner suggests a fairly narrow reading of what constitutes an enclosed area. And so when it comes to you looking to make an assessment on whether somebody working in a particular area is required to keep their mask on or is free to keep their mask off, that's something, again, you're going to want to assess on a case-by-case basis and to seek appropriate legal counsel so that you make sure you're making a decision that you're comfortable with ultimately. All right, so I know I threw a lot at you there. I know it's an important issue and we've got more to cover here, but I just want to say this. I know this is yet another compliance requirement that we're facing, and that we're facing it where there's a lot of uncertainty. There's certainly gaps in the information that we're being provided and any number of questions that are unresolved by the guidance and determination that's been put forth. As I mentioned before, though, we've been down this road already. Frankly, we've been down it several times. And just speaking from my personal experience, I've yet to come across a situation where we aren't able to figure out a path forward that makes good sense for our organization, that makes good sense for the health of our employees, our customers, everyone else who we deal with, and that puts us in a good compliance position moving forward. So even though there's this gap, right, between maybe where we want to be and where we are right now and a number of questions, again, working together, I'm confident that we can get to a good place moving forward. So hang in there, all right? Reach out to us if we can help, and you certainly have resources here at your disposal with respect to our clients. Okay, so with that, why don't we pivot here to one of my good friends and colleagues, Subha Viswanathan. Subha works down the hall from me here in our Syracuse office. He and I work together on any number of issues. One area in particular is the wage and hour area, where Subha has tremendous experience and expertise. And he asked to come on today just to give a quick overview on some of the changes that we're going to see on the minimum wage side as the end of the year fast approaches here. So Subha, thanks for being with us today.
Thanks, Andy. So yeah, as Andy said, as we approach the end of the year, as we do every year, there's changes in the New York State minimum wage. There's changes to the exempt salary thresholds. If you operate a restaurant or a hotel, there's changes to the tip credits that you can use for your employees. So this is always a good time of year to kind of revisit all of those issues and make sure that everyone's in compliance for the new year. So why don't we start with the minimum wage increases that'll go into effect December 31st, 2021. So all employees other than fast food employees, there isn't going to be a change in New York City. New York City has been stable at $15 an hour for the last couple of years. And that's not going to increase going forward in 2022. Nassau, Suffolk, and Westchester counties, the minimum wage is going to increase to $15 per hour effective December 31st, 2021. That is a $1 per hour increase from what it has been in 2021. Outside of New York City, Nassau, Suffolk, and Westchester counties, the minimum wage is going to go up to $13.20 per hour, which is a 70-cent per hour increase from what it has been in 2021. Employees of fast food establishments, and basically what this means is if you operate a restaurant where customers come to a counter and order and pay in advance, and you're part of a chain, whether it's an independently owned chain or you're part of a franchise agreement, if you're a chain of 30 or more restaurants nationwide, you're considered part of a fast food establishment. Those employers have to pay at least $15 per hour. And that has been in effect in New York City for a couple of years and actually went into effect in the middle of 2021, July 1st, 2021. That increased by 50 cents per hour to get to 15. If you operate a restaurant or a hotel, the tip credits are also going to go up. So for food service workers, and it's important to note here that delivery workers are explicitly excluded from the definition of food service worker. I know some restaurants during the pandemic have seen an increase in their delivery business and possibly a slight decrease in their in-person dining business. So if you've hired more delivery workers to cover that delivery business, keep in mind that delivery workers are not considered food service workers under the hospitality industry wage order. And the reason that matters is because there is a different tip credit available for food service workers than there is for service employees. So delivery workers, even though they're not food service workers, likely would be considered service employees as long as they meet the tip threshold, which we're going to talk about in a second. But there is a higher tip credit available for food service workers than there is for service employees. So for food service workers, which is basically in-person wait staff, busing personnel, employees who have direct contact with customers and regularly receive tips. In New York City, the tip credit's going to stay stable at $5 an hour, which means that restaurants in New York City have to pay a $10 tipped minimum wage. In Nassau, Suffolk, and Westchester counties, the tip credit is going up by 35 cents per hour to $5 an hour. So again, for those employers in those counties, the tipped minimum wage is going to be $10 an hour. And for the rest of New York State, the maximum tip credit is going to be $4.40 per hour for food service workers, which means that the tipped minimum wage for that class of employees is going to be $8.80 per hour. There is no tip credit allowed for fast food employees, which, basically a recognition of the fact that fast food employees rarely, if ever, receive tips. So for service employees, delivery workers, again, likely would qualify as service employees as long as they meet the tip threshold, which we're going to cover in the next slide. But service employees are essentially all employees of either a restaurant or a hotel who customarily receive tips other than food service workers and employees in fast food establishments. So for hotels, for instance, we're talking about bellhops, housekeepers. In a restaurant, we could be talking about delivery workers. For service employees, the maximum tip credit in New York City is going to stay unchanged. For Nassau, Suffolk, and Westchester counties, it's going to go up to $2.50 per hour, which means that the tipped minimum wage is now going to be $12.50 per hour for service employees. And in the rest of New York State, the maximum tip credit is going to be $2.20 per hour, which means that the tipped minimum wage has to be at least $11 per hour. And here are the tip thresholds for service employees. So in order to even get to a point where you can consider using a tip credit for a service employee, you have to make sure that those individuals meet the weekly average in tips received. One way to do that is just to have employees self-report tips. If customers leave tips on credit cards, it should be fairly easy to monitor that. But if there's cash tips, there's always going to be some uncertainty involved, but you can have employees self-report their tips on a weekly basis. At resort hotels, the tip threshold has to average at least $8.40 per hour in New York City, as well as Nassau, Suffolk, and Westchester counties. And it's going to go up to $7.40 per hour in the rest of New York State. For service employees in restaurants and non-resort hotels, the tip threshold has to be a weekly average of at least $3.25 per hour in New York City, which is unchanged. And it is going up to $3.25 per hour in Nassau, Suffolk, and Westchester counties. And it's going to go up to $2.85 per hour in the rest of New York State. So let's talk for a second about the increases to the salary levels to qualify for the exemptions. So for New York City, there isn't going to be a change. It has been $1,125 per week to qualify for the executive and administrative exemptions in New York City. It is going to go up by $75 per week in Nassau, Suffolk, and Westchester counties to equal the New York City threshold of $1,125 per week. It is likely going to go up to $990 per week for employers outside of New York City, Nassau, Suffolk, and Westchester counties. And the reason I say likely is because I have not yet seen an official announcement from the New York State Department of Labor regarding what the salary threshold is going to be. But historically, in the last few years, the salary threshold for the executive and administrative exemptions has always been 75 times the minimum wage. So if you take the $13.20 minimum wage, multiply it by 75, you're going to get to that $990 number. So I think we can be reasonably confident, I would say 99% confident, that is going to be the exempt salary threshold outside of New York City, Nassau, Suffolk, and Westchester counties for the executive and administrative exemptions. One thing to keep in mind here is that the New York minimum salary levels are inclusive of board, lodging, or other allowances and facilities. So if you have employees who qualify for the executive or administrative exemptions under the duties tests, but they fall short of the weekly salary requirement, but you provide lodging for them or you provide a meal allowance for them, those are allowances that can be taken into consideration under state law to meet the 990 minimum, or in other areas, the 1,125 minimum. There is no New York salary threshold for the professional exemption, but keep in mind that professionals do have to meet the federal threshold of $684 per week. That number under federal law is exclusive of board, lodging, or other facilities, so you cannot count meals or housing for purposes of meeting that requirement. There is no federal salary level requirement for certain classifications under federal law: teachers, doctors, lawyers, or medical interns and residents. All four of those classifications would likely qualify as professionals under state law as well. So for all intents and purposes, under neither state nor federal law do those types of employees have to meet a salary level requirement to qualify for an exemption. Remember that the salary level is really only part of the analysis when it comes to determining whether someone's exempt or non-exempt. This time of year is always a good time to sort of relook at your positions that might be close, and make a decision regarding whether those positions are properly classified or not. So just to review very quickly what the general standards are for the various exemptions. To qualify under the duties test for the administrative exemption, the employee has to perform office or non-manual work. The work has to directly relate to management or general business operations, and the employee has to exercise discretion and independent judgment with respect to matters of significance. To qualify under the duties test for the executive exemption, the employee has to be primarily engaged in the management of the enterprise or a department or subdivision of the enterprise. The employee has to direct the work of 2 or more full-time employees. That's basically FTE equivalent. So if it's, for instance, 4 half-time employees, that would still qualify. And the employee has to have the authority to hire and fire, or at least make meaningful recommendations about hiring, firing, advancement, and promotion. To qualify under the duties test for the learned professional exemption, the employee has to perform work that requires advanced knowledge in a field of science or learning that's customarily acquired by a prolonged course of specialized intellectual instruction. And what the Department of Labor generally looks for is evidence that an advanced degree is required, an advanced specialized degree is required for the performance of the duties. So generally, the Department of Labor would say, if all you require is a bachelor's degree, but it's any bachelor's degree, the Department of Labor's position is that that's not a specialized bachelor's degree. But if it's a bachelor's degree in engineering or information technology or something very specialized, then the Department of Labor is more likely to apply the learned professional exemption. To qualify under the duties test for the creative professional exemption, the employee has to perform work requiring invention, imagination, originality, or talent in a field of artistic or creative endeavor. That summarizes it. I will go ahead and turn it over to Katie to talk about what's happening in Albany.
Super, thanks for that overview. Very helpful, very timely. And just so everyone knows, we'll keep an eye on those minimum salary thresholds for the exempt and administrative employees under New York law, and we'll get an update out on our blog if and when we see that development. All right, Katie, I feel like I stole your thunder a little bit. You work so hard keeping track of all these Albany things, and here I am sweeping in beforehand and, talking about this juicy topic of masking. But you forgive me, I hope.
Oh, I forgive you.
All right.
We're good. Don't
right.
worry. There's still plenty to talk about. So no hard feelings on my part. So where are we in terms of COVID? Not great. Again, we are still spiking at a tremendous rate at this point. I believe it's the next slide will show it's a 63% increase in COVID cases over the past 14 days. We are now averaging more than 10,000 cases a day. That's a lot of COVID cases a day in New York State. In terms of everything else, we are seeing our hospitalizations go up. We're seeing the amount of tests go up. But the good news is we're also seeing the amount of vaccines go up as well. The number of the percentage of people receiving 1 dose has jumped by 2% in the past week. It was at 79% last week. Now we're above 81. We're at 81%. So this new spike is pushing the remainder of the population into getting their vaccines. And all of the other numbers as well, the fully vaccinated numbers, those went up by 1 percentage point as well last week. We finally are at that even number in terms of how many people are fully vaccinated in New York. Again, I still don't have the information on booster shots, but wanted to show us this map again because remember how we've been comparing and contrasting these maps to show, well, where areas that you have more vaccines, the hotspot is generally not as bad. That's not true this week. This week, we are looking right at Tompkins County. That is right in the center there. They have one of the highest vaccine rates in the state, and they are now one of the hottest spots in the state as well. What does this mean for all of us. Anecdotally, it's really hard to tell right now, but it does appear that the Omicron variant is infecting people, and it is infecting people who are fully vaccinated. And that's not new. We did have breakthrough cases, plenty of breakthrough cases with the Delta variant, but it is happening at a fast rate. So turning really quickly, the Supreme Court yesterday decided not to take up a challenge to New York's healthcare vaccine mandate. This is very significant. This means that New York's healthcare vaccine mandate stays in place. It means that officially, there is no religious exemption for that vaccine mandate. That's big that the Supreme Court decided not to take up this case. That is, that keeps this in place and sets it forward in New York. So that's the law in the state. Turning to, what else is happening as well. I don't know if New York City vaccine mandate. We still don't have anything new. The guidance is coming tomorrow. That's what we've been told. There is no executive order or commissioner's determination from New York City regarding their vaccine mandate. Again, I expect that's all coming tomorrow. I put Eric Adams question mark in there because, again, new mayor is coming in by January 1. He wants to do a midnight inauguration on January 1. So it remains to be seen whether or not he will keep that New York City vaccine mandate in place. Finally, I've been getting a lot of questions about what about the definition of fully vaccinated? Has the definition of fully vaccinated changed? No, the CDC has not changed the definition of fully vaccinated. Will the CDC change the definition of fully vaccinated to include booster shots? I don't know. Generally speaking, if they did change that definition, then it would show, numbers wise, we would look bad because not as many people have gotten their booster shots. But does it make sense to, or should they? It remains to be seen. It really depends on how effective the boosters are at, one, preventing the Omicron variant from infecting you, or two, preventing the other strains of COVID that exist and other variants that exist from infecting individuals. So that definition has remained the same. It's still the 2 shots for Moderna and Pfizer and the 1 shot for Johnson & Johnson. Will it change? I don't know. Should it change? I don't know. That's the best I can offer to all of you. And with that, I believe, I have one last thing. Just wanted to poke Andy one more time for stealing my thunder. So that's it. Back to you, Andy.
That was impressive on the fly. We didn't plan that either.